Illegal immigration, writes Kavanaugh, is especially pronounced in LA, sanctuary city, among other locales in the United States. And about 10% of the people in the LA region are illegally in the United States. 10%! It's crazy. They can't seek a broad injunction restricting immigration officers from making investigative stops. The entire enforcement apparatus can come to a grinding halt because some liberal judge decided so, at least unless Congress and the president have some other approach to this. By illegally immigrating into and remaining in the country, they are not only violating the immigration laws, but they're also jumping in front of those other non-citizens who follow the rules and wait in line to immigrate into the United States to do it legally. Victory out of the Supreme Court. 6-3 decision coming down. And acting U.S. Attorney Bill Esseley, he's over in L.A., is celebrating this. He said, the Supreme Court just stayed the district court's order. Okay, so the high court staying the lower court order that restricted immigration enforcement in California. So if you recall, Trump deployed the ICE individuals and agents to go and make the arrests, and they said you can't profile essentially these illegal aliens. They said only basically white males who are Mormon, who are on bikes in white shirts, or who are working on the 7th floor of businesses in downtown can actually be questioned. Otherwise, if you question anyone else, you're a racist. You can't ask a Mexican person about being an illegal alien. That's a bigoted thing to do, is what their argument was. And you thought that's pretty interesting because the police can target high profile crime areas all over the place. They can target high traffic drug zones. They can target repeat offenders. They set up task forces like East Valley Task Force in Arizona every July 4th, and all the cops go out and they just hang out outside the bars and the weed shops and they just arrest people. And so this is criminal law that we're talking about, and it's already been well established. We've got this concept called reasonable suspicion. Cops can use indicia to develop reasonable suspicion and then make the arrest as necessary. And so here he says, we argued that the order that said you couldn't use any of those indicia, like you can't say, oh, they speak Spanish, oh, they're at Home Depot, oh, they look like this, or they're wearing that, or they're transacting with this group of people. Can't do any of it. They said, we argued that this was overly broad, aiming to hinder our ability to apprehend and remove illegal aliens in Los Angeles. Now, he says, we are a nation of laws. Federal law enforcement is non-negotiable and cannot be curtailed by any court. If plaintiffs disagree with immigration laws, they should address Congress, not a single judge. And that's exactly right, okay? And Congress is not a neutered body, definitely is emasculated. And they just sit around and don't do much of anything, but they could do a bunch of stuff. And if they were so upset about what Trump was doing, they could pass some legislation or do something about it. They could impeach him if they wanted to, but they're not. And of course, they're not making their arguments to Congress. They're just going to judges like Breyer and just asking him to invalidate the entire Trump enforcement effort. And so the Supreme Court came down today. And so a little bit of procedural orientation. This is a stay. So Trump got stopped from enforcing the law by an injunction from the lower level court. They're saying, can you please stop that lower level injunction so we can actually do our jobs? We haven't litigated this up to the merits yet. I haven't had oral arguments or full briefings on this out of the Supreme Court, but it's just kind of an early positioning. Can the stay be in effect so that he can enforce the law? That's where we're at. Now, it's a very short majority opinion, as you'll see. And we're going to have a much bigger opinion from Judge Kavanaugh in a concurrence, and then we'll hear from the dissent, the whiners. So the application for the stay was presented over to Justice Kagan, and the one that's referred to the court is hereby granted. The July 11th order that was entered by the lower level judge is stayed. Sorry, Judge. Pending the disposition of the appeal in the United States Court of Appeals for the Ninth Circuit and disposition of the petition for a writ of cert to the Supreme Court. So in other words, the lower level order doesn't have any effect right now. It's working its way through the appeals. The order was in effect while it was working its way through the appeals, but now it's not. So it's a reversal of power. So now this is going up. They say if we don't accept the case, then the stay shall terminate in the event cert is granted. Once we send down judgment, the stay shall terminate then. Okay, so it's not permanent. When there's another resolution, Ninth Circuit decides, our stay will be lifted. And if the Supreme Court decides, then our stay will be lifted, right? So we're going to allow it to process, but the judge was wrong. The judge does not have the right to stop Trump from enforcing the law. And so Justice Kavanaugh is now concurring. So he's going to explain and flesh this out a little bit more for us for the thick-headed judges who speak to the media. Says, I vote to grant the government's application for a stay, explaining the Immigration and Nationality Act authorizes immigration officers, the law, okay, the law says this, to interrogate any alien or person believed to be an alien as to his right to be or to remain in the United States. Wow, it's pretty obvious. I wonder if the judge just missed that statute. Says here, immigration officers, according to the law, may also briefly detain an individual for questioning if they have a reasonable suspicion based upon specific articulable facts that the person being questioned question is an alien illegally in the United States, Trump has the full power to do it. It's in the law. And this is the Code of Federal Regulations, which is interpreting the U.S. Code, explaining here, and the case law backs it up too. We had a 2025 case. We had a 1975 case. We had a 2002 case. And reasonable suspicion is, one of the most litigated concepts in the law. I mean, it's like the beginning of every criminal case. Like, oh, why'd you get stopped? Reasonable suspicion. Oh, and then you develop probable cause and you conduct the arrest. Okay, we got it. Like, it all starts with this. So it's fleshed out. This is not like new. This is not dictator Trump coming down here and taking over America. The reasonable suspicion inquiry turns on the totality of the particular circumstances. And you hear cops say that all the time. It's like, when you don't know what else to say, well, why'd you do that, officer? Well, the totality of the circumstances. And judges are like, oh, that's really smart. The government estimates that at least 15 million people are in the United States illegally. At least. Many millions illegally entered or illegally overstayed just in the last few years. Illegal immigration, writes Kavanaugh, is especially pronounced in LA, sanctuary city, among other locales in the United States. And about 10% of the people in the LA region are illegally in the United States. 10%! It's crazy. Meaning about 2 million illegal immigrants out of 20 million. Okay, that's like 4 Wyomings. I'm pretty sure if you do the math on that. 4 Wyomings worth of illegal aliens in California. So it's like no wonder they have to support them because they're a very vocal, very numerous group. Not surprisingly, given these extraordinary numbers, U.S. immigration officers have prioritized immigration enforcement in LA. Obviously, there's 2 million people there. It's going to take a lot. The government sometimes make brief investigative stops to check the immigration status of those who gather in locations where people are hired for day jobs, which is just openly illegal, right? Saying who work and appear to work in jobs as construction, landscaping, agriculture, or car washes, and they don't require paperwork, and therefore attractive to illegal immigrants, they call them. And so who do not speak much, if any, English. Now, if the officers learn that the individual they stop is a U.S. citizen or otherwise lawfully in the United States, they promptly let the individual go. If the individual is illegally in the United States, well, that's illegal. So they arrest the individual and they initiate removal proceedings. So they just go where the illegals are and they say, well, are you illegal? And they say, yes, I am. They say, oh, great, you're gone. Now, immigration stops based on reasonable suspicion have been an important component of immigration enforcement. Okay, so even outside the context of criminal law for decades, across several presidential administrations as well. In fact, in this case, however, the district court in California, these maniac judges, it's been the same forever, except now, where the U.S. district judge in California stopped ICE officers from making investigative stops when they identify these factors, these indicia, these check boxes. You say, oh, check. Okay, that's reasonable suspicion. I've articulated some facts and I can explain how that leads to what I think might be a problem, and you investigate it. Saying here, but if you're an ICE agent in California up until today, you couldn't ask about presence at particular locations like bus stops, car washes, day laborer pickup sites, agriculture sites, and the like. The type of work one does, can't ask about it at all, can't target construction workers, can only target the white Mormons who are preaching, riding around the countryside. Speaking Spanish, nope, gotta go talk to the English speakers who are running Fortune 500 companies in the 7th floor. Or speaking English with an accent. Apparent race or ethnicity. Again, so it's like if you look at a Mexican guy and you say, oh, you might be illegal because you're here at a day laborer center and you don't speak a lick of English and we can see what's happening, that you can't do it. Sorry, it's like 3 strikes, you're out. That's like, those are indicia. Applies to every other person in America. If you are selling drugs and transacting drugs, maybe you're just selling oregano or something. Oh, I just grew this in my garden. But cops come up, they investigate it. Oh, it's just oregano. And they let you go. So the government contends that the injunction will substantially hamper its efforts to enforce immigration in LA. The government has therefore asked the court to stay the court's injunction, and they've granted that. Now, Kavanaugh explains, to obtain a stay from this court, the moving party must demonstrate, so Trump must show, that there is a fair prospect that if the district court decision were affirmed on appeal, that this court would grant cert and reverse it, right? So you have to show that. Now, the moving party also must show the likelihood that it would suffer irreparable harm. Now, those 2 factors are the most critical here, says Kavanaugh. And particularly in close cases, the court also considers the balance of the harms on this little scale that we have and the equities of the parties and public interest. Where does it fall on the scale? So in my view, the government has made, says Kavanaugh, a sufficient showing that they are going to win. To begin with, given the significance of the issue to the government's immigration enforcement, this court would likely grant. If the Court of Appeals in the 9th Circuit affirms the lower level judges, we're going to reverse it. In addition, on 2 alternative grounds, the government has demonstrated a fair prospect of reversal as well. Now, first, under this court's decision, okay, the Supreme Court says, we've already talked about this, and these other judges should have paid attention. We already said in LA, Los Angeles versus Lyons, that the plaintiffs probably lack standing. They can't seek a broad injunction restricting immigration immigration officers from making investigative stops, the entire enforcement apparatus can come to a grinding halt because some liberal judge decided so. In Lyons, the Supreme Court case from 1983, the court held that the standing to obtain future injunctive relief does not exist merely because they experience some sort of a past harm and fear its recurrence. You need more than that. What matters is the reality of the threat and the repeated injury. You can't have subjective apprehensions about this. Well, we're scared we might get arrested and deported. Okay, a lot of things might happen to you. Doesn't mean that they will, and you can't sue over your concerns. Plaintiff standing theory largely track that. We already rejected it in Lyons. Now they're trying to say, well, we have standing. No, you're the same as those plaintiffs. Like in Lyons, the plaintiffs here who were suing, they say that they were the subjects of unlawful enforcement actions in the past, namely being stopped for immigration questioning allegedly without reasonable suspicion or unlawful presence. And like in the Lyons case, the Supreme Court case from before, these plaintiffs also seek a forward-looking injunction to enjoin law enforcement from stopping them without reasonable suspicion in the future. So all law enforcement is handcuffed. But like in Lyons, these plaintiffs, these people suing, they have no good basis to believe that law enforcement will stop them. Why are they going to stop you in the future based on these prohibited factors? And certainly no good basis for believing that any stop is imminent. And so therefore, they don't have standing. You need a substantial likelihood that you're going to be wronged in a similar way, and they can't show that here. So plaintiffs and their standing theory is especially deficient in this case because immigration officers also use their experience to stop illegal immigrants based on a variety of factors. So even if the government had a policy of making stops based on factors that are prohibited, immigration officers might not rely only on those factors when they stop them in the future. That's the totality of the circumstances that applies everywhere. Now, second, even if they had standing, the government is also going to win on the Fourth Amendment issue, okay? Because that's what we've got here. Now, to stop an individual for brief questioning about immigration status, the rule says the government must have reasonable suspicion that person is here illegally. Now, reasonable suspicion is a pretty low standard. It's a lesser requirement than probable cause and considerably short preponderance of the evidence standard. Okay, it's more likely than not. 51% more likely, you go. Whether an officer has reasonable suspicion also depends on the totality of the circumstances. And this has been in our precedent and our case law forever. They're citing these two cases right here from the Supreme Court. Now here, the circumstances include that there is an extremely high number and high percentage of illegals in LA, that those individuals tend to gather in certain locations to seek daily work. They work in certain kinds of jobs, day labor, landscaping, agriculture, construction. Those don't require paperwork. And any other factors are all part of this. Not speaking much English, coming from Mexico or Central America, all pretty good indicia since, you know, there's 2 million of them who flooded across in this one city. So to be clear, apparent ethnicity alone cannot furnish reasonable suspicion. It's not just like, oh, you look a little bit Mexican to me, you're getting out of here, right? There's a whole other list that they're going through. Reasonable, articulable facts. However, it can be a relevant factor, clearly, when considered along with other salient factors. And so under this court's precedents, which we've been talking about forever, says Kavanaugh, not to mention common sense, those circumstances taken together can constitute at least reasonable suspicion of illegal presence. Obviously, it's common sense. So importantly, reasonable suspicion means only that immigration officers may briefly stop the individual and just inquire. If the person is a citizen or otherwise, they're free. It's over. It's a brief encounter. You can move on. Only if the person is illegally in the United States may it proceed further. And so in short, says Kavanaugh, given this court's precedents, the government has demonstrated a fair prospect of success, both on standing and Fourth Amendment grounds. To conclude otherwise, this court would likely have to overrule or significantly narrow two separate lines of precedence. The Lyons line, you got to erase all those cases, and the Burgioni line. All of them have to go. It's ridiculous. Like huge branches of the judicial tree just getting lopped off because some judge is mad Trump's arresting illegals. The government has also demonstrated that it would likely suffer irreparable harm if the injunction is not stayed. So it is in this case, says Kavanaugh, particularly given the fact that there's millions of them here, the myriad significant economic and social problems that are caused by illegal immigration, they already fleshed that out in a prior Supreme Court case. And the government's efforts to prioritize these have been passed by Congress. Congress actually enacted laws giving them the power to do it. Now, notably, the lower level judge's injunctions threatens contempt sanctions against immigration officers who make brief investigative stops that they say violate my injunction. So now he is punishing law enforcement for enforcing the law that is on the books. The prospect of such after the fact judicial second guessing and contempt proceedings will inevitably chill lawful immigration enforcement efforts, which is the entire point. So on the two most critical factors, Kavanaugh continues, the government is going to win. Now let's talk about the balance of the harms and the equities, one of our favorites. It's the old balancing scale. As with many other applications applications for relief to this court, we must balance these. And the harms and the equities may appear weighty on both sides. And when that happens, when it's like, well, illegals and citizens, and in those circumstances, to borrow from Justice Scalia, rest in peace, and his apt words from a different context, trying to determine whether one party's harms or equities outweigh another party's can be akin to judging whether a particular line is longer and a particular rock is heavy. It's all kind of, sometimes it doesn't work. Pick the wrong line. Moreover, in a case like this, says Kavanaugh, involving government action, balancing the harms and equities can become especially difficult and policy-laden. That is because a court must balance the harms that are to be regulated and how this is going to impact the parties. But in any event, the balance of the harms and the equities favors the government, America, the people. The interest of individuals who are illegally in the country in avoiding being stopped by law enforcement for questioning is ultimately an interest in evading the law. Like, what are they trying to protect? What are they protecting? The right to evade law enforcement, essentially. That is not an especially weighty legal interest. Like, we're not going to protect that. We're not going to say that we're going to wipe out two entire branches of case precedent just for this. To be sure, I recognize and I fully appreciate, says Kavanaugh, that many, not all, but many illegal immigrants do come to the United States to escape poverty and lack of freedom and opportunities in their home countries and to make better lives for themselves and their families. I think that's true. I think that I would agree with that. Now, and I understand that they may feel somewhat misled by the varying U.S. approaches to immigration enforcement over the last few decades. Totally. Yeah, and it's not a humanitarian thing either, right? To bring in illegal aliens in violation of our law. If they really wanted to be humanitarians, the Democrats and the Republicans, they could have just passed some immigration statutes and just started bringing in these people like, Canada was. But they couldn't really do that because they knew it wasn't popular. Our people in our country don't want to be invaded by foreigners who are then going to shatter our culture, take over our cities, waving foreign flags all over the place, killing our citizens. It's enough. But the fact remains that under the laws passed by Congress and the president, they are acting illegally by remaining in the United States. You might have sympathy. You might, oh, well, it's just the law. Change the law. You don't have to create a class of people who live in a gray illegality area. At least unless Congress and the president have some other approach to this. By illegally immigrating into and remaining in the country, they are not only violating the immigration laws, but they're also jumping in front of those other non-citizens who follow the rules and wait in line to immigrate into the United States to do it legally. For those reasons, the interest of the government win, and the interest of illegal immigrants in evading questioning and thus evading the detection of their illegal presence are not particularly substantial as a legal matter. It's not like we're protecting your First Amendment right, but they think that. They think, oh, it's due process rights for these illegals, and you can't be a bigot and ask them questions. Moreover, as for stops of those individuals who are illegally in the country, the questioning in those circumstances is typically brief. Individuals may promptly go if they're here legally. And finally, although the Weiner dissent emphasizes the force allegedly used by immigration officers, that's not what we're talking about in this case, Sonia. The district court enjoined the government from stopping individuals for questioning, not about force at all. The injunction is silent as to the use of force. The court didn't even mention it. So what are you talking about it for? And it's not even necessary for the injunction to address the force question because it's about the Fourth Amendment. Now, to the extent that excessive force has been used, Fourth Amendment prohibits that and can't do it. Now, I agree with the dissent that there's a law about excessive force and you can't use that, anywhere. But to reiterate, this injunction is not about that. So in short, the balance of the harms and the equities favors the government and America, especially in an immigration case like this one. It is also important to stress the proper role of the judiciary. Judges, whiners talking to the media, the Supreme Court doesn't have our back. Oh my gosh, who wrote that? I want to know who wrote that. Was that Gia Cobb? Was that Judge Chutkin? Don't tell me that was Boasberg. Was it Zenas? It might have been her. Saying it should come as no surprise that some administrations may be more laissez-faire, free market immigration, the libertarians out there, and the Bidens, I guess, just saying, well, to the world, just, osmosis into whatever country suits them best. Saying Article 3 judges may have views on this policy approach. They may think that they're better, smarter, fairer, more just, but judges are not appointed to make policy calls. They're judges. We merely ensure in justiciable cases that are actually cases and controversies that the executive branch acts within the confines of the Constitution and the federal statutes. And just as this court a few years ago declined to step outside our constitutionally assigned role to improperly compel greater executive branch enforcement, so we can't force them, okay, like the court said, we can't force Joe Biden to enforce the law, I guess is what they found in U.S. versus Texas, Biden versus Texas. We now likewise must decline to step outside our role to restrict it. So the executive has discretion. Joe Biden wants to open the borders and flood our country with illegals because Alejandro was in favor of that, and that's fine. He can do that, Supreme Court said. But Trump can do the same. And so the surge should continue. Now, in sum, the government has demonstrated a fair prospect of success on the merits and has met the other factors for an interim stay, and so I therefore vote to grant the the application for a stay and to lock down that lower level judge. Now, the dissent is here, and it's the three whiners. At least Jackson's not writing this one. So she took a little break. Like, no. She's like, no, I'll write it. Like, nope, we're good. I'll take this one. Are you sure? Nope, it's ours. So in early June, writes Sonia, the government launched immigration enforcement raids across LA. And here, they were armed and masked, and they pulled up the car washes, and they were seizing individuals. They didn't even ask a single question. Give me a break. So a federal district court found these raids were part of a pattern. They said, well, they're targeting their race. They say they're targeting their Spanish or English, type of location, and more. But instead of allowing the district court to consider these troubling allegations in a normal course, a majority of this court decides to take the once extraordinary step of staying the order. It's not extraordinary at all. Here you go. All right. It's another grave misuse of our emergency docket. Okay, so this is going to be a procedural dissent. It's not going to be interesting. We should not have to live in a country where the government can seize anyone who looks Latino, speaks Spanish, and appears to work a low-wage job. And that's not exactly it, right? It's not like you're like a cashier someplace. Like, you got a license or like a, grocery bagger or something like that, right? Entry-level jobs, okay? You have to go get validated you're a citizen and do that. It's not low wages, Sonia. It's illegal jobs who are being paid under the table. And all of those things, if you are Latino, you speak Spanish, you're outside of Home Depot, probably a pretty good person to ask a question. And by the way, they're only asking them a question. It just are determining, are you a citizen or not? What's your status? And she's going to call that a seizure. And I think you could debate that, right? What is an actual seizure? When does a seizure occur? Is questioning a seizure of the person? I think it could depend on the consequence, on the context, but it's not seizing, asking questions about a person's status. And that's what the issue is. Like, so she's turning this into something that it clearly isn't. Like, the case is not even about seizing people. If it's about seizing people, how come they didn't file a habeas petition? Did somebody get seized here? Who was it? No, it's not. Nobody was seized. Not in this case. In other cases, they can file their own habeas petitions and say, I was illegally seized by Trump, blah, blah, blah. That's not what this is. This is an attempt to try to stop the enforcement of immigration law in America by judges who just decide that they know better than everybody. So she says, yeah, we launched a huge operation and they were carrying handguns. Cops carry rifles down in Mexico. It's not anything new for them. They shouldn't be too freaked out about it. Other operations at large encounters include more force and fewer questions. They were tackling Latino day laborers. And if you're fleeing, I mean, that seems like it's probably a pretty good indicator that you're not a citizen. So fleeing from law enforcement is the same thing. The operation has sparked panic and fear across LA. Well, in our country, we want to enforce the laws. If you're panicked because you broke the laws, you have an option to leave. If you're panicky and fearful, just go back home. Kristi Noem will fly your butt out of here. No problem. They'll put you on a nice flight, give your kids teddy bears, whatever. The government moves beyond background demographics and saying, other companies who've hired, it bears little resemblance to the government's hypothetical, and you get there. It's Sotomayor. So they just love illegal aliens and they'll fight for them. They deserve due process. They deserve all the benefits of the doubt. The case law that's been in existence for decades and that has already been litigated by the Supreme Court will continue to stand, the liberal whiner judges notwithstanding.